As per the records of NCRB, more than 90 cases of rapes were reported daily in India, and it happens many times that the rape survivor or any person do not know how to punish the perpetrators if an offense of rape are committed against them, and what and how the justice delivery system of India operates in such cases. So in this video, I am going to explain the steps that can be taken by a woman or any person to punish such perpetrators. So first, let's discuss what kind of acts are recognized as rape in India. It is too important to notice that in India, rape is not a gender neutral offense and only a man can be held liable for the commission of an offense of rape. A man is said to commit an offense of rape if he penetrates his penis into vagina, mouth, urethra or anus of a woman, or make her to do so with him or any other person, or insert any object or part of a body not being the penis into the vagina, urethra or anus of a woman, or manipulates any part of the body of a woman so as to cause penetration into the vagina, urethra, anus, or any part of the body of such woman, or make her to do so with him or any other person, or applies his mouth to the vagina, anus, urethra of a woman, or make her to do so with him or any other person without her consent or against her will. In such cases, a man is said to commit an offense of rape. Important to note, if a consent is obtained by coercion or putting any person on whom a woman is interested under threat of death or hurt, in such cases such consent will not be considered and a person will be held liable for the commission of an offense of rape. The punishment for the offense is defined under section 376 of the IPC. It states that a person who commits an offense of rape shall be punished with rigorous imprisonment with the description of a term which shall not be less than 10 years but can be extended for imprisonment for life and shall also be liable to fine. Further, IPC prescribes different punishment for aggravated form of rapes, such as when rape are committed by a person who is in fiduciary relationship, by a police officer, by a doctor. In such cases, the punishment can be more harsh as is mentioned in section 376. Now, let's so in such cases, the first step that can be taken by a woman or any person who knows an offense of rape has been committed against any woman can first register an FIR. So FIR can be recorded under the provision of section 154 of CRPC. FIR is generally information that is given by a person regarding the commission of a cognizable offense to the officer in charge of police station. In this case, this cognizable offense is rape. For the offense of rape, it is mandatory that the information that is given regarding the commission of rape will be recorded by the women police officer with greatest care and caution, incorporating all material information which are directly or indirectly connected with the commission of crime or are likely to form the important evidence. Important to note herein that the victim can lodge an FIR in any police station in any state or district. It is not important to lodge an FIR only in the place where an offense of rape is committed against her, and the police officer cannot refuse to register an FIR saying that this case does not fall under jurisdiction. If they do so, a person can report to any senior officer of police. A copy of information which is recorded under section 154 of CRPC shall be given to the person who is giving information without any cost. And if there is any delay in recording the FIR by victim or informant, the reason for such a delay shall be explained in the FIR. Certain safeguards are provided in this case. As rape cases are of grave nature, investigation in this case is monitored by the DCP of the district concerned, and initial special reports shall be issued by the gazetted officer immediately. Similarly, DCP or in charge of the zone or district SP shall give an investigation officer a proper investigation as to how he should conduct an investigation and collect an evidence from time to time. As per the case of Khemchand and others versus State of High Court of Delhi, it has been held that the one copy of FIR should be sent to the District Legal Service Authority in case there is need to get help from the lawyers that are enrolled in the District Legal Service Authority by the victim or informant. Next, what if victim is a minor? In these cases, if the victim is a minor, consent and presence of parents at the time of recording of statement and FIR is necessary. If the guardian is not available, consent and presence of representative of an NGO or member of the Child Welfare Committee shall be obtained by the police officer during the recording of statement or FIR. The safeguard is provided to protect the identity of women and also from the stigma in the society that someone has raped her. A safeguard has been provided that the IO investigating officer shall wear plain clothes during investigation or interview in such cases, and it is the duty of the police officer to ensure that at no point of time such child shall come in contact with the accused, as the same is mandated under the POCSO Act and the CRPC. Also, in certain districts there is special juvenile police units or the local police. It is notified to them that if the child against whom an offence has been committed, if is in need of care and protection, then the police officer should take immediate arrangement to forward the child to the nearest hospital or to the shelter home within 24 hours of the making of report, as well as carry an investigation to find the legal guardian of the victim in appropriate case if required. In no case or circumstances the police officer shall detain any child at night in the police station for any reason. This is required under section 24 clause 4 of POCSO Act. If the victim does not have a place to stay, she should be shifted to a shelter home. Now, next step that can be taken if the police officer is not registering an FIR and no one, and instead of making many attempts to the police officer and the other officer who holds high rank in the police, in such cases a person can directly apply or a victim can directly reach the magistrate under section 200 of CRPC. In this case, any person or a rape survivor can file a complaint under section 200 of CRPC before the magistrate containing the information regarding the commission of an offence of rape, and on the basis of such report, the magistrate, after examining the complainant, will order the investigating officer to conduct the investigation regarding the commission of offence against the women. Now, the next step after the FIR or the complaint under section 200 of CRPC, the next step is the investigation. So investigation includes all the proceedings which are undertaken for collection of evidence, and this investigation is to be conducted by police officer. Section 156 of CRPC empowers the police officer to investigate the commission of cognizable offence without the order of magistrate. Also, and these proceedings, if taken by a police officer, shall not be questioned in the court on the ground that the case was one in which such officer was not empowered to investigate under section 156. As I mentioned earlier, that under section 200, after examination of the complaint made by the rape survivor or any person, in this case the magistrate is empowered under section 190 to take cognizance, can order the police officer to investigate whether such offence is committed or not and to take all necessary actions. Next stage is the collection of evidence. At the scene of crime, the police officer will conduct an investigation by taking footprints and collecting other relevant items with the help of scientific team including hair, blood, semen, blood fluids, ornaments which are found at the spot, and these spots are to be photographed from all angles. Also, if any teeth or bite marks have been detected, then the accused shall be taken to the dental expert for relevant examination immediately. Measures I would mention here is that if an offence of rape is committed against if when an offence of rape is committed, a woman should not wash her immediately and should only wash after her medical examination is completed, because in some circumstances or cases there is a chances of evidences being wiped out. So this can also be done by the exhibits survivors. That has been collected during the investigation shall be sealed and sent to the FSL for chemical analysis as quickly as possible. In sensitive cases, supervisory officer must issue plan of action on the same day of reporting in the form of advisory. In appropriate cases, generally in these cases of rapes, DNA analysis should also be done. And the chain of custody of exhibits should be kept safe and intact by the police officers and the person who are doing scientific analysis of the evidence. Now the next step is the medical examination of victim. Section 164A of CRPC mandates and imposes an obligation on the part of investigation officer to get the victim of rape medically examined within 24 hours from the time of receiving the information relating to the commission of such offence, in this case rape, to see if there is any marks in body or any DNA samples can be obtained which may be further can be used for the evidence in the cases. And this report of medical examination shall be immediately forwarded to the magistrate by the IO, who records the statement of the victim under 164 of CRPC. Further, it is important that the female victim shall be examined medically only by a lady doctor or under her supervision. If a rape victim is above 18 years of age, her examination can only be done after obtaining her consent, and if the victim is minor, that is below the 18 years of age, or is permanently or temporarily mentally disabled, then in cases victim is to be examined only after written consent from her parents, guardians, or in appropriate case such consent may also be obtained through the electronic means. And this report of examination is to be furnished to the victim or her parent or guardian within 24 hours by the police officer or the medical officer. Next step is the recording of statement of victim under section 161 of CRPC. As these offences are very sensitive in nature and which can impact the rape survivors psychologically, in such cases, a mental and emotional state of such victims to be observed, and improper questions should not be put to her by the police officer, as this statement are recorded by the police officer and not by the magistrate. The statement and the magistrate are recorded under section 164 that we will learn later. And it is also mandated that for recording of such information, the victim shall not be called to the police station, and it is the duty of the police officer to record the statement at the place which is comfortable to the victim at her home or where she decides for giving such information. Cases are under POCSO, that is, an offence is committed against a minor. In this case, the presence of parents or guardian of the victim must be allowed at the time of recording of such statements, and in appropriate cases where the victim is outside the country or abroad in the course of an investigation, then in such cases victim or witness can be examined through the video conference or electronic means. If the person making the statement is temporarily or permanently or physically disabled, or the victim is of different linguistic background, then the statement made by a person with the assistance of then the statement should be made in the presence of interpreter and shall be videographed. Also, along with this statement of victim, if there is any witness who has seen or a person who has first reported to the police officer, a police officer can take such person as a witness and record his statement under section 161 of CRPC. Next, statement of victim under section 164 of CRPC. If it comes to the notice of the police officer that the offence of rape is committed, in such case, it is the duty of the investigating officer or SHO to inform the judicial magistrate for recording of statement against whom such offence has been committed, and this statement is to be recorded within 24 hours when the information is received by the police officer regarding the commission of an offence. Also, a copy of statement that is made under section 164 of CRPC should be handed over to the investigating officer immediately with direction that the content of such statement under section 164 shall not be disclosed to any person till the charge sheet or report under section 173 of CRPC is filed. Also, the medical examination and the report that has been given by the medical office by the doctor shall be immediately handed over to the magistrate who record the statement of victim under section 164 of CRPC. If any delay is caused beyond the 24 hours to forward the victim to before the magistrate for the recording a statement under section 164 of CRPC, it is mandated upon the police officer to record his reason for the same in the case diary and hand over a copy of the same to the magistrate. In case of minor, while recording a statement under section 164, the presence of parent and guardian of the victim is necessary, and if the person making the statement under section 164 is temporarily or permanently disabled or has a different linguistic background, in such cases the statement is to be recorded with the assistance of an interpreter or special educator, or such statement shall be videographed. Now, the treatment. It is important to treat the victim with care, honor, and sensitivity, and the officer interacting with the victim should be courteous, and indecent questions should not be put before the victim which has a capacity to embarrass or harm the dignity of the victim. If the victim is not accompanied by any member of a family, then the information about the commission of such crime should be given immediately to her family, and the victim and the identity of victim shall not be made public through print or electronic media, and the same is for the juveniles and children in conflict with law. However, this name and photo of such victim may be used in case diary for the purpose of the re-investigation, and the recording of such a statement and information shall be videographed. Next step is the arrest of the suspect. After it has come to the knowledge of the police officer that the offence of rape has been committed, it is the duty of the police officer to arrest the suspect of the crime as soon as possible, or if the suspect is concealing or absconding or evading arrest, the IU shall make a request to the court for the issue of warrant of arrest of the suspect, or if the arrest warrant could not be executed because the person against whom the warrant has been executed or is concealing himself, then in these cases the IO can apply to the court to declare the person as a proclaimed offender and move for the attachment of the property of such person. What is the procedure to be followed after the arrest of suspect? After the arrest of suspect, the procedure prescribed under section 41, 41A, 41B, 41C, 41D and section 51 of CRPC should be followed, and the police officer shall not detain in custody such person without a warrant for a period longer than 24 hours. That is, a person when arrested should be forwarded before the magistrate within the 24 hours. The suspect the suspect is to be sent after the arrest. The suspect is to be sent for the medical examination along with the injury sheet detailing injuries, scratches, bruises, or nail marks found on his body as per section 53A of CRPC. This procedure is very important because during examination there can be a marks or DNA or different things can come to light during the examination, which can help the case of victim in a great manner. It is also important to note that the personal clothes of the accused that were worn by him at the time of commission of crime should be seized and sent to FSL for the examination, and he should be medically examined to prove that he had a physical capacity for committing the alleged crime. Now, the next step is the submission of charge sheet. In these cases, all offences against women shall be promptly investigated within 60 days as per section 173 of CRPC, and the quality of investigation should not be compromised. It is the duty of the IO and SHO to ensure that all material documents such as medical examination report, FSL report, test identification, relevant daily diary, and the Rojnamcha sheet, etc. are included within the charge sheet. The views and opinion of the prosecuting officer shall be taken before filing of the charge sheet. The advance copy of the charge sheet shall be supplied to the prosecutor and the victim or informant without any cost. What is the duty of IU and SHO during trial? It is mandated that an officer not below the rank of sub-inspector, ideally the IU, should be appointed as the holding IU to monitor the progress of the trial of the case, and he or she should submit a progress report on each date of the trial, which should be put to supervisory officery including the SP. It is the responsibility of the IU to ensure timely production of prosecution witness for briefing by the public prosecutor or the assistant public prosecutor. Further, service of summons are to be made to ensure the presence of witness wherever possible, and summons should also be issued in the e-format. The service of summons is important to ask for a person to come before the court and make his or her statement, which is generally referred to as the examination in chief, and which is further cross-examined by the defense counsel. It is only after the cross-examination that the statement can be considered as an evidence and can be used for the adjudication in such matters. So thank you for bearing with me. I hope this video will help you.